If you run a business that undertakes an extreme sporting activity, such as you take people parachuting, I was going to say whitewater rafting, may be dangerous, may not be, bungee jumping, playing backgammon, anything that's dangerous, maybe not all of those are relevant, but if you undertake an extreme sports business, should you have your clients sign an extreme sports waiver? Stick around and I'll tell you. G'day everyone, Simon Zarifa here, contract lawyer. That's all we do, contracts. Okay, so you're running a business where someone has, or one of your clients has the potential to get hurt. So you may take them parachuting, or you might take them mountain biking or something like that, where you teach them how to jump, jumps. Should you have your client sign an extreme sports waiver? Well, I'll break this down for you. The simple answer is bloody oath. That's Australian for yes, definitely. Why? Well, simple. If you get your clients to sign an extreme sports waiver, doesn't really matter what you call it, but it's an exclusionary type clause. It's a waiver in your favor. That means they are giving up their rights to sue you and your business if they suffer an injury during the activity. So it is in your best interest, if you run one of those businesses, to have the participants, your clients, sign an extreme sports waiver so they can't sue you for contract, they can't sue you in tort, and they can't sue you under any sort of statutory or legislative regime as well. So what you want to do, I don't want to get too legalistic here, but in contract law, there's a principle called Contra Preferentium, which basically means a judge will interpret a clause in a contract against the party that drafted that clause. So if you're putting forward a waiver and asking someone to sign it, a judge will interpret that waiver against you because you're asking them to sign it. So the counter to that is you want to make sure the waiver is correct, simple to read, easy to understand, and there is no doubt what it's doing. Now, because that waiver creates a contract between you, your business, and the client, by way of that contract, the party is contractually agreeing to not sue you in contract. So if you breach a contract, they're also not, or they would also be asked to agree to not to sue you in tort or under one of the torts like negligence. So if you are negligent in operating your parachuting business, because they've signed the waiver, they've contractually agreed not to sue you in negligence. And also, if you have some liability under some sort of statutory regime, so legislation says that you as the operator of that business would be liable, you can actually, in some cases, not all, but in some, you can actually get that waived by having the person sign a waiver in your favour where they clearly agree that they won't sue you under any sort of legislation or statutory acts or regulations. So that's why if you're running an extreme sports business where there's a real risk that people could get hurt, you definitely 100% want those people to sign a waiver. Hope that helps.